Thank you. I suppose it's to come back to the whole issue of treatments, and I believe, Minister and the Taoiseach and present even here today, that we have received a lot of assurances from yourself, and that all options will be available or explored, and that this will really be a rare event because of that. Really, I accept that assurance, but when I read this section, and even as you have proposed and amended it, it really, to me, simply prescribes a procedure or sets out a procedure whereby a woman having her medical situation assessed can establish her legal eligibility for an abortion or not. And I have heard you comment many times that, well, the use of the word only means this, but clearly not everybody takes it to mean that. Least of all, I'm referring to lawyers in this case, and I would agree with Deputy Conlon posing the question. We go back to the Health Committee hearings, and we know that at a certain point, Dr. Veronica O'Keane actually didn't see her role as a treatment in that situation, but rather assessing eligibility for a procedure or not, which a woman in that situation would ask for. I feel that the nub of this is that you have again and again, which really goes against reassuring me every time, point out how subjective this is. And when we are faced in Oireachtas hearings, which were publicly held, aside from people who have contacted us besides, with the prospect that at a certain juncture in relation to the issue of treatment, you see these professionals equally qualified who would have a divergence of view on what the next step is, well then I think in order for this legislation to be truly restrictive in respect of the provision in the Constitution protecting the life of the unborn, then you need to be more prescriptive than you are. And I don't believe that it is fair to be asking us to imply, or that surely this must be the case. You have referred to also, Minister, that a duty remains in practice with medical practitioners to have due regard to vindicate the life of the unborn with due regard to the life of the mother. But in fairness, that is nothing new to us, and that has always existed. And if I might just give you the example of the 6 young girls who were sent out of this country for terminations, where a psychiatrist had assessed them, which to my mind, that duty from the X case and the Constitution obviously was still there, but yet we see a situation where we were told in the hearings that you could find a case like this, maybe 1 in 50 years or 1 in 500,000 pregnancies, and it would seem that, notwithstanding that the odds for these young girls in state care are a lot higher, and in fact it really doesn't add up in my view. So I just feel, I suppose simply put, that you're assuring us will not stand up in a court of law. And we need to see stuff in black and white. And there is a legitimate question being asked here about the use of the word only. A woman is entitled to refuse treatment, and the X case basically says that in a situation where her life is at risk because of suicide, accepting that as the situation, she's entitled to refuse treatment. So therefore, the only option for the medical practitioner, the psychiatrist, is to certify in that situation. Now, I have made a request to you, Minister, which is, I suppose, not necessarily my ideal request, but I have asked that if we're really given any legitimacy or credibility to the right to life of the unborn being vindicated here, that at the very least, where a woman does not have a mental illness and she is suicidal, that that there will be a cooling off period from the time she makes the request and the medical assessment is conducted, and that there would be a cooling off period or a pause for a week to 10 days to allow things perhaps to settle, And I say that not just from my own perspective, but medical evidence was given at the health committee hearings, that in fact, when somebody is in a heightened state of anxiety, distress, suicidal ideation, that the way to deal with them is to slow things down. You don't make immediate life-changing decisions in that scenario, and it would accord with that evidence, and it would give some credibility to the fact that that we are actually taking serious our obligation to vindicate the life of the unborn. And at the moment, quite frankly, Minister, I think you're asking us to read too much into this, and while you can make your argument and I can make my argument, why do we need to be arguing about it? Why can't we put something down in black and white here that would satisfy people concerned? And I don't know what's stopping you from doing that if it's truly intended that this would be restrictive.
Margaret, and the last speaker before we adjourn or suspend for lunch is Deputy Peter Fitzpatrick.
Patients that present themselves with suicidality must be treated with compassion and respect.
We speak to the Amendment 32.
Oh, yeah. The bill is all about saving lives.